All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Welcome to the Court of Appeals. It's so different to be in here without masks and without plexiglass. It's a new day, and I hope it stays this way. I'm Judge Valerie Zachary. To my right is Judge Allegra Collins. To my left is Judge April Wood. Assisting us today are Deputy Clerk Roderick McFarland and Officer Richard Remillard. This afternoon, we are hearing SPX Corporation versus Arrowood Indemnity Company. With regard to the appellants, how have you divided your time?
Your Honor, Josh Durham representing Appellant Continental. We have decided to take 10 minutes for rebuttal. Of the primary 20, I will be arguing roughly about 13 minutes on collateral estoppel and res judicata. Ms. Mackay, who's admitted pro hoc in this case, will take about 7 or 8 minutes. The remainder of that opening portion to talk about Viking pump issues. And then we've decided in the 10 minutes of rebuttal if we might be able to have just a minute or two to confer with counsel for Old Republic and Federal as to how much they want to address in rebuttal as to what may have come up on during the SPX's argument, if that makes sense.
Okay. Do you have any problem? That'll be fine.
Thank you, Your Honor.
You may proceed.
Thank you. May it please the court, again, Josh Durham for Appellate Continental Insurance Company, and for the record, I'm joined by Kevin Roque of our office and Laura Mackay from Hinkhouse Williams Walsh in Chicago. Your Honor, we are here today to ask this court to reverse the trial court's May 21, 2021 ruling, and not just to reverse it, but to enter summary judgment in favor of Continental that liability under its policy should be determined on a pro rata basis rather than an all sums basis. Your Honor, words have meaning. Words are important. This is one of the fundamental rules that we use in our law practice. When words appear in a contract or a document or a statute, it's presumed that those words have a specific meaning, that they are not surplusage. I mention this, and I start with this because it's critical to our res judicata argument. Judge Spainhour in the preceding action said that the final judgment is binding on all parties. SPX naturally would like to discount those words, but they are the key to our res judicata argument. It seems from the briefs that the only real dispute as to the elements of res judicata in this case concern the final element as to whether there was a final judgment on the merits between the parties. I don't think any of the other elements of res judicata are in dispute.
Excuse me, may I interrupt?
Yes.
I have some questions about the jurisdiction of this court to hear this matter. Are you prepared to address those?
I can, Your Honor, and they are very similar to the principal parts of our sort of core appellate argument, because it is established without question that a party may appeal an interlocutory order if it affects a substantial right. And res judicata, if there is a risk of inconsistent verdicts or judgments, is clearly a substantial right. And then collateral estoppel, a party has a substantial right to be free from trial on the same issue that has previously been decided. And it's interesting because case law says, with regard to collateral estoppel, a party only needs show a colorable case for collateral estoppel that the continued trial may impact their substantial right to be free from trial of an issue that's already been established. So we believe we've established more than a colorable argument as to collateral estoppel that this doctrine is in play. And then we think because of the sort of core part of our res judicata argument that we firmly establish that that affects a substantial right as well.
Well, are there any unresolved issues remaining in this suit as far as your client's concerned?
I believe there are some, I think there are maybe some duty to defend issues that may still be pending, but that still does not take away from the core substantial right that's affected by res judicata and collateral estoppel.
So can you tell me, even if we were to accept that there's a substantial right, what is it about having it heard now that makes it different from having it be heard when the entire case is over?
Your Honor, I believe that the court's language in the In re pedestrian walkway case is particularly applicable to this case. And that case basically said that there were a number of parties, there were a number of interests affected, and this very issue came up. And the court there said, given the number of parties and trials involved in the walkway cases, the need for finality and certainty in this complex and exceptional litigation, and I think this is applicable here, and the likelihood that dismissing the present appeal would only delay the ultimate review of the subject matter now at issue, we're persuaded that disposition on the merits would expedite decision in the public interest. We know from the record that there are thousands upon thousands upon thousands of underlying asbestos claims asserted against SPX, for which not only Continental, but my fellow appellants and other insurers are going to be on the hook for. And the key issue is, are they going to be on the hook for all sums or just a pro rata portion? And for Continental, that's a difference of $20 million, which is their $5 million per policy over the 4 policies, or is it going to be a fraction of that? And we submit that resolving this key issue now works to the benefit of all parties, not just appellants, but also SPX and the claimants in all of those underlying cases, so that all the parties can go ahead and plan right now as to what their obligations are going to be, rather than waiting to some undetermined point in the future.
Well, aren't there a lot of pending issues, though, that will affect how much, say, Continental will have to pay for the asbestos claims?
The only issue in the complaint asserted against Continental is this: how to determine the liability. There's no breach of contract claim. That could be a future action, but right now is it all sums or pro rata?
Well, aren't there questions remaining about when coverage starts? Like does it start, from the first day of diagnosis and things like that will greatly affect the amount of the claim.
I'm not sure if that's at issue in the trial court. I'm getting a no that it's not. So I don't believe that's an issue, Your Honor. I don't think that's an issue. And that's a sort of a fundamental point, I think, where some of these other cases differ in terms of that say that a sort of preliminary ruling on coverage is not immediately appealable. I mean, those cases don't have collateral estoppel and res judicata issues that we have. But if that's where we were, a lot of those cases involve whether there's coverage or not to begin with. I mean, coverage is not at issue in the underlying case. I mean, it's not that this is a matter of one insurer trying to avoid coverage. There's coverage. It's just a matter of, is it going to be all sums, policy limits, or is it going to be some portion of that?
So, and you're speaking on behalf of Continental and Old Republic too?
I'm Continental, and I think that could be an issue that Old Republic or Federal could agree to. But that's my understanding, and we'll certainly make sure we reserve time.
So none of you are litigating coverage?
That's correct, Your Honor.
Can you address the claim that the 2010 order, which dismissed the claims in regards to Continental, your client, and OR and FIC were dismissed without prejudice, and the allegation that therefore res judicata does not apply in this case?
Yes, Your Honor. So the judgment, the final judgment language is particularly interesting. And Kevin, if we could pull up 813. And so hopefully this tech will work. There we go. So page 813 of the record, this is from the final judgment in the prior case. And the Judge Spainhour in that case, in paragraph A on page 813, says 2 very important things. He mentions the prior Granite State, Twin City, New England Reinsurance summary judgment orders, and says that those are hereby confirmed and have the force and effect of a final judgment or decree. Ties into my why words matter sort of argument. If this order were limited to just those three parties, Judge Spainhour could have absolutely stopped right there, but he didn't. He went one step further, and he said these orders shall be binding on all parties to this case with respect to policies addressed in these orders. That binding on all parties, again, is key to our argument about collateral estoppel and res judicata.
Well, didn't he then later in that same order dismiss you as a party to the case?
He said on page, I don't know if you can get 814, I don't know that I've got that one saved, but on page 814 of the record, Judge Spainhour says that all of, and we'll pull that up, he says all of SPX's remaining claims against other remaining defendants are hereby dismissed without prejudice. He does not say all claims against Continental in this case are hereby dismissed with prejudice. He says all of the remaining claims. Now, what are the remaining claims? Because we contend the claim about allocation, the pro rata versus all sums allocation, had been established. That claim was resolved higher up in the order at the language we just looked at when he said binding on all parties.
But wasn't he referring to the primary and the umbrella?
There were drop-down issues that were still in play as to whether or not certain policies dropped down. There were other lines of coverage policies at issue. So the Continental comes out of the General Signal line of policies. There were other lines involving other predecessors for SPX that were still at issue. I believe that's what it was referring to, not those that were resolved by binding order up in paragraph A on page 813.
What about the argument that we're looking here in this case about these excess policies as opposed to what Judge Zachary just said about the umbrella policies?
Well, that's what I'd like to go to the, can you pull up the chart, the Exhibit 1? No, the Exhibit 1 chart. There we go. So this chart that we've got displaying now, and this is language that SPX, they focus on the portion of Judge Spainhour's language that says, with respect to the orders addressed in those policies. Understandably, they like to try to avoid the final judgment language with that. But Granite State, Twin City, and New England Reinsurance moved for summary judgment in a prior case. We know that. And they were granted summary judgment. Now, why were they granted summary judgment? Because everybody in the preceding case admitted that the underlying policy controlled what the obligations of the excess carriers were. SPX admitted that a number of times in the preceding case. In fact, they said the coverage issues turn solely on the interpretation of the underlying coverage. And they said that any decision, whatever the court decides with respect to the primary policies, would be binding on the excess insurers if the insurers are still in the case at the time. What I've done here is color-coded what those underlying policies are. These are the policies addressed in the order because we know to determine what the obligations are on an excess carrier, the trial court had to examine these underlying policies on the right in order to grant summary judgment on an all sums or pro rata allocation issue. And these are, if the court looks at the top box, and these are all the compilations from the record, these are the exact same policies that control Continental's obligations. The green policy was one that Granite State had in play. The yellow, both Granite State and Twin City had. The blue, Granite State and Twin City had. And then the purple, Granite State and Twin City had as well. So the same policies were addressed, consulted, interpreted, construed, and that's what controls the obligations on any excess carrier. It's not like Continental has different language. SPX has not pointed to any different language in a Continental, their excess policy that controls the issue. In fact, on page 37 of their brief, they make the point that the fundamental issue in their mind is, what does this particular policy mean? And they cite 2 pages in the record, and they note in a footnote that there is material equivalent language in 2 other policies. This is not a Continental policy that they're referring to. The 4 policies they are referring to are these same color-coded policies that we just looked at. So they can't say this issue, this claim was not resolved in the prior case because Judge Spainhour looked at what that actual language means and determined it was pro rata allocation instead of an all sums allocation. So, Your Honor, we contend that there was a final judgment on the merits. There is a risk of inconsistent results, and in fact, we're already facing that because of the same language. In one case was pro rata allocation. In this case, it's been determined for some insurers to be all sums. Twin City, Granite State, and New England get pro rata from that same language.
So is your argument that there's the potential for inconsistent verdicts because your verdict might be different from somebody else's verdict who got pro rata versus yours is all sum? Are those the inconsistent verdicts you're talking about?
That's the inconsistent results, correct, Your Honor, because we're looking at the same language.
But isn't our case law not inconsistent verdicts between you and another party, but an inconsistent verdict for you in a different case should the trial go forward?
Your Honor, again, I think, well, with our argument that Judge Spainhour's language is that this is a final judgment binding on all parties, we think we're a party to that. We think it's same claims. We think we got advantage of that, not just that another carrier got advantage of that. We think we got full advantage of that language in the order. So we submit that was a final judgment. So we believe it's inconsistent as to.
But your argument then is that I guess that the decision in this case is inconsistent with the prior decision, correct? But
correct.
Then the harm has already been done if it were from your point of view. So looking at it now versus at the end of the case, that isn't basically, that doesn't fit within our jurisdiction for inconsistent verdicts.
I disagree, Your Honor. We submit that we have a binding judgment saying pro rata. We know, given Judge Bridges' ruling below, he's holding us to an all sums allocation. That is what will ultimately be entered, and that's an inconsistent result.
Sure. I mean, I think your argument is that it was wrong, correct? But for this, when we're looking at an interlocutory appeal, which is I think what we're all concerned about up here, is that when we're looking at an inconsistent verdict, we're trying to figure out what exactly might be inconsistent going forward.
Well,
if it's already happened.
Well, that just seems a little inconsistent to me that if the case were filed against us and we just filed a 12B6 right off the bat, saying, hey, look, we resolved this previously, that the court, based on that question I'm hearing, is that risk of an inconsistent verdict might exist at that point because, yeah, we agree that you might have gotten the benefit of the prior judgment, which said pro rata, and now you're facing a trial where that issue is going to be determined again, and it could go against you and be all sums. So there's a risk of an inconsistent result at that point. It seems sort of illogical to me to say now that we're further into the case, and we know that the court has ruled, we know this is going to be reduced to a final judgment at some point, to say, well, now it's too late because it's already happened. I hope the court sort of understands the distinction I'm trying to make there. We know there are inconsistent results. And so we think the res judicata applies. But collateral estoppel applies as well in that, and I just want to refer to the McInnes case because I'm over my time and I want to get Ms. Mackay on the Titan valve or the Viking pump issue. The McInnes case on collateral estoppel I think is directly on point. And it sort of expands the collateral estoppel doctrine to no longer require mutuality of estoppel between all the parties. And it said, Plaintiff McInnes had its day in court on the issue it now seeks to relitigate. Both actions are based on the same breach of contract under which Ms. Hall's obligations were exactly the same as her husband's. And we submit that's on point with the case here. SPX has already argued that underlying contract language and what the obligations are, and it lost on that issue, and it's now seeking to relitigate. Thank you, Your Honor.
May it please the court. I am going to address the Viking pump issues, but if I could speak to the inconsistent verdicts just quickly. In this case, in our action, Twin City and New England, which sit above Continental and follow form of the same policies, got an order the same day as Continental's May 21st, 2021 order. Twin City and New England got a pro rata allocation order. So we have inconsistent verdicts in this case, following form to the same policy language. The rationale for that's not entirely clear from the court's order with respect to Twin City and New England, but the court found that a balancing of the equities favored Twin City and New England, not Continental. Again, it's not really clear, but it is absolutely inconsistent in this action. But if I could move on to the Viking pump issue, I'd like to address the error the trial court made with respect to the court's apparent finding that the other insurance condition in the underlying umbrella policies that's incorporated into the Continental policies mandates all sums allocation. It does not. The court, if you could go to the record 1850. On June 5th, 2020, the trial court entered an order with respect to a number of other defendant insurers' policies. That's London, Lamrack, and Travelers. And if we look at paragraph 10A of that June 5th, 2020 order, the court found that under New York law, all sums is the proper method of allocating indemnity costs when the insurance policy contains or follows form to a policy with one or both of the non-accumulation clauses at issue in Viking Pump. The trial court's June 5th, 2020 order, that's referenced there, found that the excess policies at issue in that order contained one of these non-accumulation conditions or followed form to one of the Viking Pump non-accumulation conditions. Continental does not dispute that factual finding. That's correct. If you go to the record at 1957, on May 21st, 2021, the trial court entered the order from which Continental now appeals, in which the trial court concluded at paragraph 23 that the Continental and Old Republic excess policies either contain non-accumulation provisions or follow form to policies that specifically contain non-accumulation provisions. The trial court was correct. The Old Republic policy contains the prior insurance and non-accumulation of liability condition at issue in the Viking Pump case. And the Old Republic policy can be viewed at the record at page 1178. The trial court erred, however, in concluding that the Continental policies contain or follow form to a non-accumulation condition. It's undisputed they don't contain or follow form to one of the two Viking Pump conditions. It's also undisputed that the underlying Northbrook and New England policies don't contain one of the two Viking Pump conditions.
I'd like to ask a quick question.
Sure.
Are your affirmative defenses limited to allocation?
Our affirmative defense, Continental's affirmative defenses are not limited to allocation, but when you review the affirmative defenses, they are largely prophylactic in the event that, in case of, and so they're asserted to preserve.
Well, are they defenses to coverage?
There are defenses to, and I understand what Mr. Durham said in terms of Continental is not arguing that asbestos claims are somehow excluded from their policies. That's not an argument. There are issues in terms of the scope of coverage, what may fall within or without, but it is not about not being covered. And I did want to clarify one issue with respect to the limits. It's true, all sums allocation puts $20 million, at play right now. When Mr. Durham referred to a fraction of the limits, it's a timing issue. The $20 million in limits is still there, whether it's pro rata or all sums. But timing is critical in terms of the insurer being able to evaluate and prepare for payment of claims. And so that's the issue there.
Okay.
It's a timing issue.
Has your client withdrawn those defenses?
Continental has not yet withdrawn those defenses, but they're not being pursued given, SPX's sole count against Continental was for all sums allocation. And that's been done, and that's why we're here. And I just want to say that the critical takeaway from post-Viking Pump New York jurisprudence is that pro rata allocation governs long-tail claims unless a policy has one of the two Viking Pump conditions. And I'm sure the court has seen in our briefing, Brooklyn Union Gas and Danaher are the two cases post-Viking Pump. There are other cases post-Viking Pump that apply all sums allocation. but only where you have one of the two non-accumulation conditions that were at issue in Viking Pump. No New York court has construed other language to equal that language. And I will turn my time over. Thank you.
Thank you.
I think that's, yeah. Yeah, there we go.
May it please the court, my name is David Wright. I practice with Robinson Bradshaw in Charlotte and have been co-counsel with Covington and Burling in this case. I woke up this morning thinking that we've educated children, had grandchildren, all kinds of things since 2006 when we first filed these cases, and I've been in it through two fine trial judges and have made some good friends of my insurance colleagues in the midst of it all, but it's been going on a very long time. I thought that, and the first point I do want to say, which I think is evident from the briefing, is the first case really dealt with the primary policies, which were the yellow policies on the chart that you've seen, and a slice of the green policies as first level umbrellas, and only one excess sure granted state. So in response to one of the panel's questions, it really dealt with the primary and umbrella carriers, and what we had from the excess carriers in the first action was claims of non-justiciability. We're too far up, you can't reach us, we should be dismissed with prejudice. Judge Spainhour kept him in the case until the end when he let him out with prejudice, without prejudice. Where we are now in the case, I thought it would be helpful to tell this panel, because that's happening right now. We have more summary judgment motions scheduled to be heard in April and in May. One of those in May concerns the scope of the Continental policies in terms of defense cost coverage. So the question is, for settled claims, does that include, do they have to pay defense costs or not? And that's a contested issue that's going to be resolved. The way the scheduling order is in this case, what it provides is that 90 days after Judge Bridges makes this final decision with respect to summary judgment, then any remaining factual issues will be tried. Otherwise, we would expect to see a final judgment in this case. So to use a golfing analogy, we are on the back nine and the clubhouse is in sight after more than 5 years of litigation in this case, which really brings up the question, why would this court at this juncture entertain an interlocutory appeal when we're so close to being done in the final case? And I think that really goes to the first point that I would say, and I believe my good colleague here, Mr. Durham, really collapsed the inquiry of res judicata, collateral estoppel, the merits of that with respect to the substantial right doctrine, which I don't believe is correct under this court's jurisprudence. And I would say, having reviewed many of those cases, it's not exactly a tranquil pond when you look back over all the court's decisions with respect to res judicata and how it affects the substantial right, and trying to implement really two Supreme Court decisions, Bachweg and the Turner versus Hammonds case, to try to determine exactly what the interplay looks like. And I would say, though, that the first two things that the court, we would urge the court to consider are, one, whether or not there is something other than a substantial right being effective, what would be lost? And I believe, Judge Collins, you had this question, what would be lost if we waited? And that's a part of this court's jurisprudence to say something has to be lost as a part of the inquiry. Here, in addition to being close to final judgment, what we would point out is this order is an allocation order only. It's a declaratory order. It does not award money damages. It does not, there's no injunctive relief. At this point, SPX has not allocated any dollars to these Continental policies or Old Republic or Federal, which are way up the line. So there's nothing that Continental is required to do that would operate to divest themselves or prejudice them from a substantial right.
Could it be that claims might be made in the interim against some of these policies, and then they will be forced to pay out those under an all sums policy? And then, I'm sorry.
No.
You go where I'm going.
What I would say is this order does not require payment of anything. So if we're looking at whether the order, which I think is the inquiry, does the order impact a substantial right? The order does not do that. Is it possible that down the road at some point there may be some allocation or request for payment? I suppose that's possible, but we don't have a lot of time left in this case. So in terms of the operative standard, does the order require a forfeiture or prejudicing of the substantial right? We would say in this case it does not. And that's separate and apart from the merits of the collateral estoppel or res judicata issue. The second part we would point out really that is unrelated And this is the point where I would say it's a bit of a checkered history, and I believe this court has said that there was a split in the authority amongst the Court of Appeals on this point. But when we're looking at the question of possibility of inconsistent verdicts, I believe the law now is clear and settled in this court that you can't simply show that res judicata or collateral estoppel is not like qualified immunity, where you just say, I have a motion, it's been denied, my right is the right not to stand trial, and therefore I can take an interlocutory appeal. The jurisprudence of this court, what we've said, and we've cited the Heritage Operating case, and I believe the other case that we've cited in our brief is the Dewey Wright Well and Pump Company case, which talk about this, but there are decisions from this court in the last several years which emphasize the point that it's not simply a collapsing of the res judicata collateral estoppel issue, but it requires showing of the possibility of inconsistent verdicts. And we don't have that here. A verdict is a word that means something, to use my good colleague's line here, and a verdict means a factual finding. This is not. This is a legal finding, and it means the decision by a jury. And granted, there are some decisions that talk about a judge or a jury, but in general, when you look at it, it's two trials relating to two factual issues. And there are cases, I'm not going to cite them on Rule 28, we didn't cite them in our brief, but they're out there, which basically say if it's an issue of law resolved on summary judgment, then there's no possibility of an inconsistent verdict. So I would say those are the two preliminary points that we get to say, is there a substantial right affected, and why would you entertain it at this juncture in the case before we even talk about the merits of the res judicata issue?
What about the argument that I heard that it would be beneficial for all parties to have these, I guess, these cases decided at this point? It's one less case to decide, and it's a whole lot faster than waiting till the end.
Yeah, I think the waiting to the end is not going to be very long. I mean, I believe we're going to be this, after nearly 6 years of litigation, I believe Judge Bridges is going to want to be done with this case this year. So I don't think we're talking about waiting very long. The problem is this is not a cost-free exercise, as this court knows. Because what happens is there gets to be a delay in the case, and the record indicates, we cite in our brief, that for a 3-year period through 2018, my client paid out $72 million in fees as we're waiting to resolve these issues with our insurers. So as the longer we wait, the more cost that we have to incur. So it's not a cost-free exercise here. The other thing I would say is, in terms of resolving this now, is we've got pending motions in May that talk about the scope of these very policies. And to Judge Zachary, your point, I did not hear my good colleague Ms. Mackay say that they were waiving their affirmative defenses. They continue to assert those. The issue of trigger of coverage continues to arise. So why would we resolve? I guess why would it be consistent with the public policy of this court and the strong reason not to have piecemeal review, to go on and review one part of a ruling when other issues remain in the case vis-a-vis these continental policies? The last point, Judge Collins, I would make in that regard is, and if history be any guide, what happens is when you get to the end of this case and you get all these rulings, some of these cases drop out for appeal. And parties resolve the issues, they become less significant because of other rulings, and that's exactly what happened when I was up here before arguing in 2017. We had a number of these cases, a number of these issues dropped out. So I think in the end, if the encouragement, and the final point I make is this would be a bad precedent for a complicated insurance coverage case and an invitation, quite frankly, for further delay. So I think for all of those reasons, we would urge this court to exercise what it has historically done with respect to the substantial right doctrine in this context and dismiss this appeal.
I just have one more question. I noticed in, I think it's your letter to Judge Bridges arguing against 54B certification, you said that the issue remained whether bodily injury, sickness, and disease in asbestos cases occurs continuously from the date of an underlying claimant's initial inhalation. I think Judge Zachary asked about that question to you. Is that still remaining before? Yes,
we believe that, and we filed motions with respect to that issue. We put forward affidavits with respect to this trigger of coverage from scientists who talk about the diagnosis of asbestos disease and how it affects individuals. We're waiting to see exactly who's going to contest us on that point, but we have not had folks line up and say we concede with respect to the trigger of coverage. So that is the trigger of coverage issue that I referred to that I do believe is still live in the case. So what we, the third point I want to make, and my colleagues spent a good bit of time on this, is really talking about the judgment at issue here. And if we could, at this point, pull up our slides, is that possible to look at the judgment slide for a minute, which the court looked before? Here's the point that I want to make at the outset with respect to looking at this from a collateral estoppel res judicata standpoint. We say there is no prior judgment and no prior adjudication regarding the Continental, Federal, or Old Republic policies. So that the all sums / pro rata issue was not actually litigated in the first action by these parties, and there was no judgment on the merits construing the meaning of the Continental, Federal, or Old Republic policies. And that has implications both under preclusion principles, i.e. if there is no former adjudication, if there is no actual litigation, then there can't be preclusion. It also has implications, back to a question Judge Collins you asked, about whether there's inconsistency or not. If there's no resolution of the issue, there can't be an inconsistency because by definition there wasn't a prior resolution with respect to their policies in the action. And it is important to understand the context of that decision, where, again, those decisions were in 2009, 2010 was the final judgment. Viking Pump, which was 2016 decision, was not around. Nobody was talking about it. Nobody mentioned, I will tell the court, nobody mentioned the word non-cumulation in the 5 years we litigated in that first action. Not an issue. Viking Pump had a change in the law. So again, that litigation was focused almost exclusively on the primary policies, which largely don't have non-cumulation provisions. But here's the point I do want to make sure the court understands from me. Continental and Federal never filed any motion on the merits pertaining to their policies in the first case. Not one motion. They never asked the court, Judge Spainhour, to rule that their motions were governed by pro rata allocation. They never joined in any other insurer's motions on the merits. They took a different tack. They, again, argued there was no justiciability. That motion was denied. They were left in the case. But what the Williams versus Peabody case says, and this is black letter law, is an issue is actually litigated for purposes of collateral estoppel, not only if it's raised by the pleadings, but is otherwise submitted for determination and is in fact determined. Old Republic, only slightly different. It has no order in its favor with respect to pro rata allocation, and we'll look at that in a second. They actually joined they have one policy, and they joined with one motion, but never sought an order in that respect. And so what we have, if we look here at the, can we see, are able to see the judgment, please, on page 5? On the judgment at page 5, what it does is it lists the prior and confirms the prior orders in paragraphs 2 through 4. None of the orders in paragraphs 2 through 4, none, pertain to the Continental, Federal, or Old Republic policies. So of all these orders that are being confirmed there are for policies other than Continental, Federal, Old Republic. So these orders, it does say there, are binding on all parties in the case, but only with respect to the policies addressed in the order, which is the language the excess insurers wanted. What this judgment does not say, and what the insurers are arguing here instead, is that the orders are binding even with respect to policies not addressed in the orders. I.e., their policies are not addressed in the orders, yet they're arguing this language means that the orders are binding with respect to those policies. So what we say is this. We have the opposite, in our view, of actual adjudication. We had a strategic decision because of justiciability issues not to litigate on the merits, the pro rata all sums issue with respect to their policies, not to file merits motions, and consequently no decision and no orders on those policies. And so if we move to page 6, which we looked at previously, in this response to Judge Wood's question about whether or not the remaining claims were dismissed without prejudice, and they were. So the question is, what does that mean, the remaining claims were dismissed without prejudice? And the remaining claims would be the claims or contentions pertaining to policies that are not referenced in paragraph 2 through 4. So these insurers' policies were not referenced in paragraphs 2 through 4. So all claims regarding those policies that have not been adjudicated are dismissed without prejudice. And so under black letter law, and I don't think there's any division between the parties, if there is no ruling on the merits with respect to the policies, if they're dismissed without prejudice, then it puts them in the same position as if the lawsuit had never been filed and there's no claim preclusion or issue preclusion as well. The fifth point that we say in conjunction with this issue is that the issues are not identical. What this court has said in order for collateral estoppel to apply, and that's the only conceivable doctrine that could apply here, and I'll explain why in just a minute, because claim preclusion does not apply in a declaratory judgment setting. But issue preclusion requires that the issue be identical, and what this court has said in the Beckwith case and the Williams versus Peabody case is that this is a very close examination of the matters actually litigated have to be made to see if they're identical. And we say they're not identical for this reason. Not only was there no decision with respect to the policies, but there was no issue here. What Judge Bridges decided here looking at these clauses is that the Continental and Old Republic policies had a non-cumulation provision, and under Viking Pump, that non-cumulation provision meant all sums. Again, Viking Pump wasn't around. Judge Spainhour never heard of it, never decided it. That issue was never litigated. So if we're looking at whether there's inconsistency in the actual issues litigated between the prior action and this action, we say there was none. There was no exact identity as to the issues to implicate that. And the law is clear that any doubts about that, any doubts about whether the two issues are identical are resolved in favor of the non-moving party, because this lest we forget, all of this is their burden. It's their burden to show a substantial right. Res judicata collateral estoppel, that is an affirmative defense. All of this burden exists on their part with respect to these issues. And so what this court has said is that the burden is on the party asserting collateral estoppel to show with clarity and certainty what was determined in the prior judgment. And that's the McElhenney case that is cited, as well as the Miller Building Corporation case. So we say they can't show identity of issues here. As I indicated, res judicata, that is claim preclusion, that word's used loosely to encompass both branches sometimes. That does not apply here for two separate reasons. The first is, and we cite the Barrow case on page 33 of our brief, claim preclusion, the rule against claim splitting, if you will, does not apply in a declaratory judgment. The sole claims here in the first action were for declaratory relief against the excess insurers, and the law is clear. You're not required to bring every claim against a party when you just bring a declaratory judgment proceeding, and that's what we did here. In addition, the way that claim preclusion works is you are precluded in bringing not only claims that were actually litigated, but claims that could have been brought. Whereas here, the remaining claims were dismissed without prejudice, there's no basis upon which to conclude that claim preclusion would exist. The last part we make in our brief, and we would say if the court chooses to reach the merits of the collateral estoppel issue, is there was a substantial change in the law which we say forecloses the application of collateral estoppel here. Viking Pump effected a substantial change in the law. Judge Bridges noted that several times in his decision. There's little question about that. And Viking Pump at page 259 of its decision says, we have never, this is talking about the Newark Court of Appeals, the highest court in New York, we have never addressed the interplay between non-cumulation and prior insurance provisions and allocation. So it's a case of first impression in 2016. And what the Supreme Court said in the Settle by and through Sullivan case, that's a great name, and this court in the Tart Landing case said is adopting the restatement section 28 of judgments. It said if the issue is collateral estoppel and the issue is one of law, not fact, but law, and a new determination is warranted to take into account an intervening change in the applicable legal context, then collateral estoppel doesn't apply. So if you get through all of this and you conclude that everything I've just said is wrong, then what we would say is, look, at the very least, there's been a substantial change in the law here. And the litigant, our client, has the right at this point to have its policies adjudicated with respect to what everyone agrees is the proper substantive law, New York law, and there is zero question that Viking Pump says if a non-accumulation provision is in a policy, then you get all sums. This is particularly the case when we're dealing with these upper-level policies that haven't suffered any judgment that you have to pay out any money yet. So what we're talking about is, the idea that you would, as a North Carolina court, would allow essentially what failed to reflect a change in New York law that is applicable to policies that have not yet gotten into play would be, we say, inconsistent with what this court has said in that regard. So I will say just a few things about the merits, because that has been addressed. To make it simple, and this is not simple, Viking Pump is not simple, but what the simple part of this is that Viking Pump says if a policy has a non-accumulation clause, then all sums applies. So what we're doing here is we're looking at the clause, and what the court said is all sums allocation is appropriate in policies containing non-accumulation provisions. So the merits issue here is, are these policies in the Northbrook and New England umbrella policies, are those policies are those clauses non-accumulation clauses or not? That's the question. And the pertinent language, which is on page 37 of our brief, it appears under a condition. It's called an other insurance condition, and the Northbrook policy and the New England policies have the same thing. And if we could possibly pull up the Northbrook policies, please. So yes, and if you can just pull up the 3 sentences with respect to the other condition here, so that can be on the screen. Perfect. And the next slide that kind of pulls that out. So what we're looking at here in terms of the merits is this. I've isolated for the benefit of the court what the provisions are that Judge Bridges ruled upon in our favor, and he ruled that this was a non-accumulation clause. What Viking Pump says simply is this. If there's language that permits the conclusion that a loss is going to be covered by more than one policy, that is successive policies, prior successive policies, then pro rata doesn't work. It's a legal fiction and it doesn't apply. And so the question here really is, if we look at this and we look at these sentences, this is talking in the first sentence about pure other insurance clauses dealing with other policies. That's not what we're arguing here. We're arguing that the second and third sentence amount to a non-accumulation provision. And what that says is that if there is any other policy that is implicated here, any other policy, not just, as the insurers want to say, any other concurrent policy, but if there's any policy, any successive policy, any prior policy, then there's going to be an anti-stacking rule. That is, if there's a loss, then you can't stack the limits of all of those policies. And so we say Judge Bridges got that right. The argument to the contrary ignores, we say, Court of Appeals case law, particularly the Nesmith and Geraldo cases, which are cited at pages 39 and 40 of our brief, do not require any durational or temporal language there. And the Danaher Travelers case that they cite deals with primary policies where there's a regulatory issue, obviously not here. But what we say is simply this: any means any. Any means any policy, whether successive or not. And if you consider our argument, as we believe Judge Bridges did properly, under the canons of construction about the reasonable interpretation, about ambiguity being resolved in favor of the insured, about what a person would understand would typically be the meaning of that, and if there's essentially any doubt has to be resolved in the favor of the insured, then we believe we must prevail. Absent any further questions from this court, my argument is concluded. Thank you.
Any further questions?
Thank you.
We have no further questions. Thank you. You may proceed with your rebuttal.
Your Honors, and if we may have just a couple minutes so that I can confer with both Republic and Federal and make sure we get what needs to be done.
Good afternoon. May it please the court, I'm David Brown from the Guilford County Bar here on behalf of Appellant Federal. And I just kind of wanted to take 1 minute just to answer Judge Zachary's question in context about where Federal stands. So like Mr. Wright, I've been involved in this case since 2006 in one form or iteration, and agree we've become good friends over that time as well through a lot of these issues. So what I want to raise to the court is this. Federal has 3 policies in effect from April 1 of 82 to April 1 of 85. They all 3 sit over Continental, so we're up on top of Continental. And Continental in the first one of those 3 years is over a Northbrook policy, and over the last 2 years over a New England policy. So fundamentally what we would say is if you decide to rule on the merits of Continental's appeal, that you should rule on ours as well, because it's the exact same issue, judicial efficiency, et cetera. We're both talking about the New England policy that we both follow form to. And if not, we'll come back another day. With regard to the direct answer to Your Honor's question about where we stand, the federal policies have not yet attached. There's not been reached, so there's been no demand for payment under those policies. We've not waived any affirmative defenses. We do still have affirmative defenses to be litigated, but fundamentally, I think the issue before under the federal policies is allocation, and is it going to be all sums or is it going to be pro rata? And just briefly to the point or question Judge Collins raised, about cases that might kind of come along, the underlying cases that is, in the next, say, 18 to 24 months if we wait to come back on another day after a final order from Judge Bridges. What's unique and interesting about this case, and these substantial right cases under this court's jurisprudence are all handled on a case-by-case basis, as you all are well aware. What's interesting and unique about this case is that Judge Spainhour ruled that the New England policy is subject to a pro rata time on the risk allocation. There's no dispute about that. There was no appeal of that in the underlying case. So that's how that policy, those policies are going to be dealt with as you sit down at the mediation table and so forth to resolve these underlying cases. Under the current rules from Judge Bridges, the Continental policy over that, and then in turn, the federal policy over Continental would have a different construct, a different rule, even though they're following the same language, which I won't steal anybody's time talking about why we think that all sums does not apply here. But I do think that creates, and again, it's a case-by-case analysis, but I do think that goes to the substantial right analysis of having a situation where you've got the same policy language being handled and interpreted, and frankly, as we stand here today, having court orders in effect that treats them differently, and how does one sit down and try to resolve underlying cases in that way? And I think, I don't want to speak for Mr. Durham, but I think that was part of what he was getting at in terms of how it might serve everyone to have some clarity. So that's all I want to say about the federal policies. Thank you.
Thank you.
Very briefly, I'd just like to address a couple of things SPX's counsel said about the Viking Pump issue. The Nesmith and Geraldo cases are both before Viking Pump, and as we know from the sentence Mr. Wright read, Viking Pump never addressed the interplay between allocation and non-accumulation provisions, so those cases can't be relevant. Further, they did not address other insurance, they did not address allocation, trigger any of those other issues, and they say as much. So those cases shed no light on the issue. With respect to the language, the chart that SPX's counsel showed you, what SPX is saying is that any other in the first sentence means concurrent, because that's what Viking Pump and Consolidated Edison said, but any other in the second and third sentences means consecutive. And those words just are not in there. The hallmark, the word cumulative is not the key here. The hallmark of the Viking Pump language are temporal words, partly before, partly within, prior to the inception date hereof, continuing at the time of termination. None of that language is in the Northbrook Other Insurance condition. And if you compare the Northbrook Other Insurance condition to the condition in Brooklyn Union, they are virtually identical. What they say is if more than one policy issued by this company, concurrent coverage under New York law, more than one policy issued by this company applies to a loss, you only get one limit. or you only get to recover once. You don't get to accumulate, which simply means to add or combine together. There's no temporal aspect to that word. And SPX's counsel is trying to rewrite this other insurance condition to be a non-accumulation condition, which it is not. It is simply a limits provision that tells you how many limits you get for a loss covered under concurrent coverage. Thank you.
Thank you.
And then I will wrap it up. All this talk about Viking Pump reminds me about our petition for cert. An unsettled question of law is grounds for granting a petition for cert, and certainly this court could bring some clarity to what does Viking Pump actually mean and settle that issue for once and for all. I submit as well, if the court looks at Judge Bridges' rulings in this case, he cites that there is a balancing of equities test when it comes to res judicata, and that absolutely is not the law in North Carolina anywhere. So we submit that could be corrected on the petition for cert as well. There was mention about claim preclusion is not applicable in a declaratory judgment action. In our reply brief, we said, well, that's not absolutely the case. I'm not aware of any case where a party got a ruling on an issue in a declaratory judgment action and then was able to go relitigate that same issue. If the issue was decided, it's decided. Claim preclusion absolutely applies to that particular claim and issue. The change in law as to collateral estoppel, same thing. Tar Landing and Beasley do not support what SPX claims it says. Those involve different parties that were at issue. Again, there is no case that says a party that litigated an issue and lost it is able to relitigate that same issue because of some subsequent change in the law. That case law just does not exist. The final point is on this, whether or not an issue was tried, what controls Continental's obligations? What controls those obligations are the underlying policies. Then we ask simply, all right, has any other court looked at those underlying policies before to determine what they mean? And we absolutely know that Judge Spainhour looked at those policies and determined what they mean. SPX should not be able to relitigate that meaning in this case. Thank you, Your Honors.
Thank you. That concludes oral argument in this matter. I thank you, counsel, for your excellent arguments. We'll take this matter under advisement.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
Gotta get some warning next time, man. That thing scared the heck out of me when you did it.
David, nice job.